Welcome to the finals of the Southern Classic. We have Harvard and we have Faulkner, and we are so excited to have y'all here. Let's
I think I'm passing myself right now.
Yeah, here you go. That's
Can you hear me?
Would you like to get closer or further, Your Honor?
It doesn't matter to me.
Let's
Should they?
How's that, Your Honor?
Looks good.
Your Honor, we had two more matters we wanted to take care of.
Okay.
I want to make the court aware of the stipulation and the clarifications of this tournament. Page 2 of the clarifications, point 4, which reads, if a witness is not in the round, their affidavit is considered to not exist in the fact pattern. It may not be referenced. The only exceptions are if Dr. Huntsman discusses the material they reviewed and Jolene Tremount's interrogation as exhibits.
All right, that agree?
That is the defense's understanding as well, Your
All
Honor.
right, let me enter.
And we do have one motion in limine.
All right.
We would move to constructively invoke the rule of witness sequestration.
The defense has no objections, Your
All
Honor.
right, that'll be granted. Does that mean you're invoking the rule?
Yes, sir.
Well, the rule has been invoked, and that means that anyone who is going to testify in this trial must be outside the courtroom until such time as they have testified. I don't know to whom the rule applies, so I will ask the attorneys to help me enforce the rule. There you are.
It's constructive.
I understood that. That's why I'm going to ask the attorneys to help me enforce the rule.
Thank you, Your Honor. Witnesses,
Detective Seymour. Your Honor.
Let's see if Vince has anything. Do you have any preliminary matters?
Yes, Your Honor, I believe opposing counsel is just about to explain which witnesses were going to be constructively sequestered.
Okay. Does that mean you're not going to send them outside, or you are going to send them outside?
I'm not going to send them
We
outside.
can move on, I understand that.
Okay.
Yes, Your Honor.
Yes, sir. I think that's it for the prosecution.
Your Honor, the defense does have a few pretrial motions to make before the court.
All right,
The first, the defense moves to exclude any mention of Casey Dupree's driving while under the influence citation. May I explain?
you may.
Your Honor, the defense plans on calling to the stand a witness, Casey Dupree, who received a citation for driving while under the influence of alcohol. We move to exclude any mention of the exact nature of the citation from this trial. We are amenable to having the prosecution bring up the fact that she was in some sort of legal trouble in order to explore her bias. But we do believe, Your Honor, that it would be both irrelevant and, if the court finds otherwise, substantially more prejudicial than it would be probative for us to delve into the nature of her legal trouble and have that before the jury.
All right,
May I
you
respond?
may.
Thank you. Your Honor, this goes directly to the witness's credibility and bias. This driving under the influence ticket was made to disappear by the defendant. This directly impacts her ability to be a credible witness and non-biased.
Anything further?
If I may, Your Honor, we would argue that discussing that this is a driving while under the influence citation is substantially more prejudicial than it is probative.
All right, did it occur close in time to the other events in question,
Your Honor, it occurred within 1 year.
within 1 year?
Yes, sir.
Other than that, does it have any bearing on her testimony?
It does, Your Honor. She is a teacher. Her testimony states that if she had been convicted of a driving under the influence, she would have lost her job.
May I respond, Your Honor?
You may.
Your Honor, we are perfectly amenable to the prosecution bringing up that she was in some sort of legal trouble and that the defendant was involved and instrumental in helping her out of that legal trouble. We just believe it would be prejudicial for this jury to hear that she was driving while under the influence. This is a serious allegation involving a serious crime, and the jury members may, after hearing this, be prejudiced to her and her testimony.
Was it a misdemeanor or a felony?
It was a felony, Your Honor. It's my understanding.
To the extent that you said that you might use it, or it might be used to show that the defendant was involved in helping her get out of the offense. Is that what you're saying?
Yes, Your Honor, the defense is perfectly amenable to the prosecution
Well,
exploring
to that
that.
extent, I think it is, it would be meaningful and helpful. It would not be unduly prejudicial because it would show what was at stake. So your motion is denied.
Yes, Your Honor.
Thank you, Your Honor.
The defense has another pretrial motion to make.
Okay,
Your Honor, the defense moves to exclude any statements from Taylor Drift from the court. May I explain?
you may.
Your Honor, Taylor Drift is an individual who was available to testify that the state has chosen not to call to the stand. Because under the Confrontation Clause of the United States Constitution, the defendant has a right to face their accuser. And because Taylor Drift is not going to be testifying today, and the defense has not had the opportunity to cross-examine her, we do not have the ability to explore the credibility or the veracity of any statements Taylor Drift made to a detective for the purpose of this trial. These specifically, Your Honor, the defense is moving to exclude testimonial statements that would be inadmissible under the Confrontation Clause.
All right.
Your Honor, as far as the affidavit of Taylor Drift, we have no problem excluding that. However, any statements she made to Detective Seymour, I believe, should be admissible because it goes to the effect of the listener.
I don't know who Taylor Drift was.
May I respond, Your Honor? Taylor Drift was this case in general involves a car accident where the victim, Jacob Tremont, died, and he was the driver of the car, and Taylor Drift was the passenger of that vehicle. We're moving to exclude any statements from Taylor Drift that were made, specifically the defense is concerned with statements Taylor Drift made to the detective. These are testimonial statements that were given in preparation for a criminal prosecution.
So I'm assuming Taylor survived the accident.
Taylor Drift did survive, Your Honor.
Yes, Your Honor. Again, as I said, we are not going to introduce her affidavit at all. All we want to introduce is the statements that she made to the detective for the purposes of showing the effect of the listener and the effect on the investigation.
I'm going to sustain the objection. I think the right to confront the witnesses is very important, right? Sustained or granted.
Your Honor, with that, the defense is ready to proceed to opening statements.
All right.
Your
Are
Honor,
you ready to proceed?
yes, may I get one clarification?
Yes.
Based on the last ruling, I assume that the expert in the defense's case is not also allowed to refer to Taylor Drift's testimony.
That would be correct. And I have read that expert's report, and it was quite fascinating, actually. I will stand by my rule. I don't think the expert should be allowed to rely upon that any more than the jury. Anything further?
No, Your Honor.
No, Your Honor.
Are you ready to proceed?
We are, Your Honor.
Who's giving you up this statement?
That would be me,
You
Your
may
Honor.
proceed.
May it please the court, opposing counsel, members of the jury. Hurt people hurt people. The evidence in this trial today will show you that the defendant, Jolene Tremont, slashed open the tires of her husband's truck while he was at Funky's Bar on Friday, October 21st of 2021. In so doing, she caused the death of her husband, Jacob Tremont. You're going to see that when he got in his truck to drive home that night, his truck veered off of the side of the road, slammed into a thicket of pine trees, and he died because of her actions. Because she was hurt. She caught her husband cheating on her, and she was hurt. And she got angry, vandalized his truck, slashed open his tires, and now he is dead because of her. She didn't mean to kill him, but he died because of her actions. And now she's being charged with a second-degree murder of her own husband. Hurt people, hurt people. Ladies and gentlemen, my name is Rebecca Smith, and I, along with my co-counsel, Baron Shaw, represent the people of the state of Mississippi. As representatives of the people of the state of Mississippi, it is our duty to prove to you, beyond a reasonable doubt, that the defendant, Jolene Tremont, committed second-degree murder when she killed her husband while he was driving home from Funky's Bar on Friday, October 21st. At the end of trial today, my co-counsel is going to explain to you the elements of second-degree murder. And I want you to listen closely to him as he does. But for now, it is sufficient to say that second-degree murder is not a murder that is premeditated. She did not plan ahead to kill her husband, and that is not what we're trying to say today. I'd like to take a moment to introduce you to the victim. Jacob Tremont was a man of this community. He was a hard worker. He dedicated his time to helping others in their time of need. And when disaster struck a coastal town, he picked up and spent well over 2 months helping that town get back on its feet. He was a father, and he loved his children dearly and worked hard to provide for them. And though he took his job and his calling very seriously, he was not the kind of man to forget the simple pleasures in life. The little things like hanging out with his buddies, blowing off a bit of steam, and taking pride in his brand new F-150. I'm not going to lie to you and tell you that Jacob Tremont was a saint. I'd already told you that he was having an affair on the night that he died, but what he was a hardworking, loving, small-town man who was full of life, at least until his life was taken from him. Over the course of the next few hours, my colleagues and I are going to show you the important evidence in this case. And as we do, I want you to listen to three main things: the means, the motive, and the opportunity. First, the means. In just a bit, Detective Seymour is going to step up to this witness stand and she is going to talk to you. And she's going to tell you about the damage that was done to the truck. Mr. Shaw is going to ask her to explain the damage that was done to the truck. And when he does, he's going to ask her about what damage was caused by the truck slamming into a thicket of pine trees and what damage was caused by something else. The evidence is going to show you, ladies and gentlemen, that those tires have been altered. Every single tire had 4-inch gashes in them. And the tire right at the driver's side, right where Jake was sitting, that tire was completely flat. There was no air left in it. You're going to see, ladies and gentlemen, that it was the damage to these tires that caused the death of Jacob Tremont. Second, motive. October 21st was a Friday. In a small town, Oxford, Mississippi, there's not much to do on a Friday other than to go to the bar and meet up with your dates and have a good time. And that is exactly what Jacob Tremont did that day. Only the woman he met up with wasn't his wife. It wasn't Jolene. The evidence is going to show you that she was there waiting on him, and that she was dressed in an outfit that matched her mission. A woman who was normally dressed in such beautiful, noticeable clothing was dressed in all black and sunglasses in a bar at night. Miss Dennis was the bartender at Funky's Bar, and she's going to stand up here and tell you about what she saw that night. And you're going to hear, ladies and gentlemen, when I ask her what happened, that the defendant sat at the bar and drank and watched and waited as Jake met up with his date. And when Jake walked past her, smelling like he'd just poured a bottle of cologne on himself, there was no question where that night was going. You're going to see, ladies and gentlemen, that she got up and she confronted him, that she was angry and hurt and that she'd been drinking, and she yelled at him before she stormed out of the bar like a bat out of hell and stood alone in that parking lot. And finally, opportunity. Now, I told you earlier that you're going to hear testimony about how the tires were altered on that day. And I want you to keep this in mind, because whenever Harley Dennis is sitting up here, I'm going to ask her about a knife that went missing at the bar that night. You're going to see, ladies and gentlemen, that there was a knife that was sitting right in front of the defendant before she confronted Jake and marched out of that bar. And I want you to compare the time that she was seen leaving the bar to the time that she got in her Uber and rode home. What the evidence is going to show you is that she stood outside alone and angry for 10 minutes while she waited on that Uber. You're going to see, ladies and gentlemen, that it was the angry wife and the missing knife, the time spent alone waiting on that Uber that created the perfect opportunity, the perfect chance for the defendant to vandalize the truck that she knew her husband loved so much. Now, I can't tell you that someone is going to stand up here today and tell you about how they watched Jolene vandalize his truck. There's not a person that I can sit up here or a video that I can play for you today that shows her taking a knife and slashing open his tires, but ladies and gentlemen, that's not necessary. Because at the end of the day, the judge is going to instruct you on the law. And when he does, he's going to tell you to use your common sense to decide what happened that night. He's going to tell you that you're allowed to make inferences as to what happened. You don't have to see it happen to know that it happened. Hurt people, ladies and gentlemen. It's that simple. You might be familiar with a popular country song. The song tells the story of a girl who goes to the bar and catches her husband cheating on her. So what does she do? She goes outside, gets angry, vandalizes his truck, slashes open his tires, so the whole time she's thinking, maybe next time he'll think before he cheats. But what if there isn't a next time? What if instead of him getting in his car and driving home safely, he gets in his truck, drives, slams into a thicket of pine trees, and dies on the side of the road? That, ladies and gentlemen, that is murder. I understand her tears. She's not on trial for being angry, but ladies and gentlemen, the law is not here. The law is here to make sure that anger and tears don't turn into murder. I implore you, find the defendant guilty of second-degree murder. She didn't mean to kill him, but he died because of her actions. She was hurt, and so she hurt him. Hurt people, hurt people. Find her guilty, ladies and gentlemen. Thank you.
Thank you. Counsel for defense.
Bitter bartender and too much booze. That's what the state didn't tell you about. You heard about how Jolene Tremont was married to Jacob Tremont. You heard about an affair. And you heard about a confrontation in the bar. What you didn't hear about, and what the state didn't tell you, was about a bitter bartender and too much booze. And that's a problem. That's a problem because in choosing to bring this case, the state has assumed a burden of proof. They need to prove to you beyond a reasonable doubt each and every element of second-degree murder. So for this case, the state needs to show you three things. But first, that it was Jolene Tremont who slashed the tires of Jacob's truck. Second, that it was those slashed tires that caused Mr. Tremont to pass away. And third, that if you do find that she slashed those tires, that she slashed them with a depraved heart. The state, they won't be able to meet that burden. And they won't be able to meet it for two reasons. A bitter bartender and too much booze. You're going to hear today a lot about a bar named Funk's on the outskirts of town. You'll hear how Jacob Tremont took his lover, Taylor Drift, there, and how they had drink after drink at this bar. But you'll also learn that they weren't alone. You'll learn that, unbeknownst to them, Jolene Tremont had come to the bar to verify for herself that there was an affair going on. And members of the jury, I'm not going to lie to you. You're going to hear today about Jolene Tremont confronting Jacob in that bar. You're going to hear about an argument. You're going to hear about some screaming, about some yelling. But you're also going to hear that Jolene Tremont left that argument She left that argument, she left that bar, and then you'll hear how she called her friend. The state claims that when she was in the parking lot, that's when she slashed the tires. But what you'll actually learn is that that's when she called her friend to vent. And yes, members of the jury, she was angry. She was angry, she was screaming, she was crying, she was upset. She had just found out that her husband, the father to her children, her life partner, had cheated on her. But you'll learn that by the end of that conversation, she wasn't as angry. She had calmed down. And you'll also hear that she hung up that night because she saw someone else outside the bar in the parking lot with a bat. You'll learn that that person was Harley Dennis, the bartender. You'll also be hearing from a crime scene specialist later today. That crime scene specialist, he's going to tell how, in this case, after that argument, after that phone call, Jolene, she decided to take an Uber. But unfortunately, Jacob Tremont didn't. Despite having drink after drink at that bar, he went to his truck. He got behind the wheel and he drove. The crime scene specialist, he's going to tell you how just meters from where that truck veered off the road, there was a deep pothole. Members of the jury, throughout today's trial, there are a few things I want you to think about, just like how the state asked you to think about a few things. But what I'm asking you to think about are a few different things. Specifically, was there someone else on the night of the accident who could have had that knife and that bat? Second, was Mr. Tremont just too drunk to be behind the wheel of a truck anyway? And finally, is there even any evidence the state has linking Jolene specifically to the tires of Mr. Tremont's truck? When you've listened to all the evidence and you've heard from all the witnesses, members of the jury, I'm sure you will find, as we will ask you at the end of today's trial, to find Jolene not guilty.
All right, thank you. Who's called your first witness?
The state calls Detective Seymour to the stand, Your Honor.
Detective Seymour.
Your Honor, permission to set up the well for any exhibits.
Yes.
Also, Your Honor, can we confer with the Board of Advocates here to make sure they are in this screen for the judges on Zoom?
Yeah, anything you need to do to make that work, go ahead and do it.
Thank you.
Your Honor, I'd just ask that I be allowed to reposition myself when or if they use a demonstrative aid.
Certainly, and if you're hard of hearing, you may move closer to the jury also.
Thank you, Your Honor.
Whichever is fine with you guys. That's good to go. Can you see this? Can you guys see this?
Yeah, I
Okay.
can. Reason for the arm reach rule, and I'll tell you if you don't mind me in the trial, but you don't have to keep your hand on the podium, just big then. Touching of it when you're speaking, that kind of controls everything in such an area. Remind me to take one.
Yes, Your
Yes,
Honor,
Your
I
Honor.
realized about halfway.
Well, I'm afraid we'll pull it over for us. Are you ready to proceed?
Yes, Your Honor. The state calls Detective Seymour to the stand. And one more thing, Your Honor, can we assume all witnesses have been constructively sworn in?
You might, we won't have to do that. You go ahead.
Thank you, Your Honor. Good afternoon, Detective. Could you please introduce yourself?
Yes, my name is Maddox Seymour.
And where do you work?
I'm a detective with the Lafayette County Police Department.
How long have you worked there?
Well, I've been a police officer since 2013. I went back to school to learn more specific techniques in 2015. So I've been a detective about 7 years.
What exactly do you do as a detective?
For the most part, I investigate crime scenes.
What type of crime?
All types of crimes, ranging from misdemeanors to serious felonies like murder.
How many murders have you investigated?
I've investigated 15 murders over the course of my career. I've testified as an expert actually in 12 of those.
Now, Detective, I'd like to turn to the murder that brings you to the stand today. Detective, do you recall the events of October 21st, 2021?
I do.
What happened that day?
I was alerted to a car wreck on the side of the road on County Road 31 around 1:15 in the morning.
Now, just for the court's purposes, where is County Road 31?
That is in Lafayette County.
Now, were you the only officer to respond?
No, I was met by 2 other reporting officers.
Could you please describe what you observed once you arrived at the scene?
Of course, we saw a 2019 brown F-150 on the right side of the road. It appeared to have crashed into a thicket of pine trees, and on first glance, the driver was unconscious.
Detective, were you able to tell who else was in the car?
Yes, when we looked into the car, we did discover Jacob Tremont behind the wheel of the vehicle, as well as 1 passenger.
Was Jacob Tremont alive?
He was not. We know now that Jacob died of blunt force trauma to the head as a result of the accident.
Your Honor, referring court counsel and the witness to stipulation 19, which reads, both parties agreed that Jacob Tremont's death was neither the result of a suicide nor occurred during an attempt of suicide.
That is the defense's understanding, Your Honor.
All right.
Detective, did you take a picture of the scene of the crash?
Yes, I did.
Would it be helpful to the jury and the court to see a picture of it?
Definitely.
Permission to publish pre-admitted.
No objections, Your Honor. This exhibit has been admitted into evidence per pretrial stipulation between the parties.
All right, you may proceed.
Can we see that, counsel? If that's fine.
Is it
Yeah,
okay
can you guys
with the court?
Detective, could you tell us exactly what we see here?
Yes, so this is what we saw when we arrived on scene. As you can see, this is the damage from the crash. This is the right side of the vehicle, and this is showing all of the damage from this incident.
Could you explain the damage, Detective?
Of course, yes. The front right side of the vehicle is crushed in. What was interesting, though, is that all 4 tires on the truck were slashed. And as we can see here, impact was made on the right side of the truck, but on the left headlight, that was busted out. It didn't make contact during the accident, and so this definitely drew some suspicion.
Detective, what did you do next?
Well, we started to suspect that there may have been foul play after inspecting the vehicle, so we had the truck towed to the impound lot.
Thank you. Permission to take this down. Now, Detective, I want to move to your conversation with Ms. Dennis about the confrontation between the defendant and the victim in this case. What did Ms. Dennis tell you?
Ms. Dennis let me know that she saw Jolene sitting at the bar.
Objection, Your Honor, to the hearsay statements of Harley Dennis to this detective. These are out-of-court statements that they're using to prove the truth of the matter certain.
Who is Harley Dennis?
Harley Dennis is the bartender.
Your Honor, this is useful effect on the listener. This goes to the Harley Dennis statements affected the detective's investigation moving forward.
May I respond, Your Honor?
Right.
Your Honor, the defense has no issue with the detective explaining any steps she took in her investigation or what she personally did. We do, though, have an issue with any statements from Harley Dennis concerning what he may or may not have seen. They're using these statements for the truth of the matter.
May I respond? May I respond, Your Honor? Your Honor, talking to Harley Dennis is a step the detective took in his investigation.
I will allow him to testify as to the investigation, but I'd have to be careful of any statements that Dennis made. Is that what your objection is?
Yes, Your Honor. We have no issue with the detective, say, looking for certain pieces of evidence after a conversation with a witness, but we do have an issue with the specific statements or any summary of those statements.
What exception would apply?
Your Honor, this goes to effect on the listener, Your Honor. The detective had an investigation. She went around asking witnesses who seen the confrontation and were at the scene of the confrontation that led to the crash. And so she, in her investigative attempts, talked to Ms. Dennis, the bartender, that night.
I will allow her to testify to the extent that she relied upon Dennis's statements as to what he saw or what he did, but not what he heard. If that comes up, we'll have to look at it differently, but otherwise I'm overruling the objection.
Thank you, Your Honor. Now, Detective, let's backtrack for 1 second. Who is Harley Dennis?
Sure, Harley Dennis is the owner of Funky's Bar, and they were bartending on the night of the incident.
And did you speak to Harley Dennis?
Yes, I did.
What did Harley Dennis tell you?
Well, I learned from my investigation that Jolene Tremont arrived at the bar early that night and sat down at the end of the bar and waited for her husband to arrive.
Did Ms. Dennis tell you anything else she observed?
Yes, she said that Jolene sat there and watched for a while, but after Jacob walked by her, Jolene.
Objection, Your Honor. The defense would like to re-raise its objection to hearsay. The detective has not gone into how these statements are affecting her investigation. She's simply recounting what Harley Dennis told her.
May I respond, Your Honor?
You may.
The detective is accounting her investigation. This is after the crash. This is when she finds out that the brown F-150 left the bar, Funky's, and now she's talking to the bartender as it goes into who could have slashed these tires.
Let me ask both of you, does anybody intend to call Mr. Dennis as a witness?
The prosecution will be calling Harley
Yes,
Dennis.
Your Honor.
Okay.
They will get a chance to call.
Well, I'm gonna allow him to proceed with this line of questioning, and then if you wish to bring up anything he raises on cross or impeach him otherwise, that's certainly be allowed too.
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. I'll ask again, Detective, what did Ms. Dennis tell you?
Yes, so I found out that Jolene sat at the end of the bar that night and waited for her husband to arrive. Once he arrived there with his mistress, Jolene sat and waiting for a while. But once Jacob walked by her, I found out that she did confront him. There was a big falling out, there was yelling, there was screaming, and then she stormed out of the bar, nothing short of a rage.
What was Ms. Dennis doing?
Objection, Your Honor, to the speculative nature of the statements, nothing short of a rage.
Your Honor, she has personal knowledge. She was the bartender that night.
Overruled. You may proceed.
Could you rephrase? Could you say that again, Detective?
Sure, yes, I learned that Jolene Tremont stormed out of the bar that night in a rage.
And where was Ms. Dennis during this?
Ms. Dennis was at the bar doing their job.
And could you tell us anything else that Ms. Dennis told you?
Yes, of course. Ms. Dennis told me that they did step out of the bar for a brief period of time that night. They let me know about a missing knife while they were gone.
A knife, Detective?
Yes, they told me that before they went outside, they sat a paring knife. They'd been used to cut lines right in front of Jolene Tremont. They stepped outside for a brief period and came back, and the knife had disappeared.
Detective, how did that affect your investigation?
Well, at that point, we decided to consider Jolene Tremont the primary suspect in this case.
Did you speak to Ms. Tremont?
Yes, I did.
What did she tell you?
She admitted everything that I already knew, that she went to the bar that night to watch what her husband was doing, that she sat there, she watched, she confronted him, and that she stormed out of the bar.
Your Honor, I apologize. We forgot to take up a matter in pretrial motion. Can we constructively assume that Ms. Tremont is sitting at the defense's table for identification?
That's amenable to the defense, Your Honor.
All right. You may proceed.
Detective, do you see Ms. Tremont here today?
Yes, I do. She's sitting right over there at the end of the table.
Let the record reflect that the detective, the witness, has identified the defendant as Miss Joan Tremont.
It will.
Did Miss Tremont tell you what happened once she left the bar?
Yes, she told me that she went outside, called an Uber, that she stood outside waiting for it. And at that point, you know, I already had heard of the potential means to commit this crime through the knife. And here right in front of me was the opportunity. She told me just completely honestly that she stood outside waiting for an Uber. And so at that point, we considered that an opportunity for her to have committed this crime.
Were you able to confirm this?
Yes, I was.
How?
Ms. Tremont had an Uber receipt from that night.
Your Honor, permission to publish previously admitted Exhibit 4.
You might.
Any objection?
Defense has no objections. Again, per trial matters, we stipulated that this exhibit
Let's
be.
move on.
Detective, what is this?
This is the Uber receipt from that night.
And what time does it say on the Uber receipt?
This says 12:15 a.m.
And what time did Miss Tremont leave the bar?
I can't be 100% certain, but she did tell me that she stood outside waiting for her Uber. So there was a period of time where she stood outside before 12:15.
How long was that period of time?
10 minutes.
Is 10 minutes enough time, Detective?
Absolutely. This would be the perfect opportunity to have committed this crime.
Permission to take down this exhibit.
All right.
Now, Detective, after your conversation and your investigation, was the defendant, Ms. Tremont, a suspect at this time?
Absolutely.
Based on?
How could she not have been a suspect at that point? Based on everything that we had gathered, she was our primary suspect.
Thank you. No further questions. Pass the witness.
Any cross?
Yes, Your Honor. Before I begin, may I ask opposing counsel's permission to use their demonstrative aid, specifically of Exhibit 2, the photo of the accident?
Opposing counsel has no objection, Your Honor.
Good. You're safe.
Thanks, sir.
May I? What did he like?
For now, yeah.
Okay.
So, may I proceed with the cross-examination from here, Your Honor? Good afternoon, Detective.
Good afternoon.
I just have a few questions about your investigation for this case.
Okay.
You told us earlier that when you arrived on scene, you were taking photos, right?
Right.
When you got there, there were two people in the truck that you found that had veered off the road, right?
That's correct.
Unfortunately, the driver of that was Jacob Tremont, right?
Jacob Tremont, yes.
And Jacob Tremont, he was pronounced dead at the scene, right?
He was, unfortunately.
There was also a passenger in that truck, right?
There was.
You know that passenger to be Taylor Drift, right?
Yes.
The detective, Taylor Drift, she survived the accident, right?
That's correct.
I want to be clear for the jury where this accident happened. The right side of the truck, that was the side that had collided with the pine trees, right?
Right, that's accurate.
The right side of the truck, that's the passenger side of the vehicle, right?
Right, absolutely.
And so that passenger side, so that was the side that Taylor Drift was sitting in.
Right, but as you know, the driver's side is only a couple feet to the left,
Oh.
so far away from the right side of the vehicle.
Of course, Detective, but I just wanted to be clear for the jury that the person who was sitting closest to where the truck impacted the trees, she survived the accident, right?
Objection, relevance.
May I explain, Your Honor?
All right.
So I'll ask the question again, Detective. The person who was seated closest to where the truck impacted the trees survived the accident.
Yes,
And Jacob Tremont, who was sitting further away, didn't.
That's correct. He died of blunt force trauma to the head as a result of the car accident.
Detective, you recognize Exhibit 2, that photo of the accident, right?
Yes,
Specifically, I wrote it down in my notepad. You said that the photo you took, this photo, you said that this is what we saw when we arrived on scene, right?
yes,
Detective, in this photo of the truck, the airbags didn't deploy, did they?
we can't see the inside of the truck in this photo.
Detective, you don't see any airbags though in this photo, right?
I can't see the inside of the vehicle at all.
Detective, you're
Objection, accident.
Overruled, you would say.
Detective, you're saying you can't see the inside of the truck at all?
No, I can't see the dash of the truck where the airbags would be positioned at all in this photo.
All right, Detective. Now, you knew that this truck, it was coming from a bar in town named Funky's, right?
No,
Detective, in your investigation, you went to a bar named Funky's, right?
yes, but I didn't know when I arrived at the scene of the truck that they had come from Funky's.
My apologies, Detective. I meant later in your investigation, you found out that that truck, it had come from a bar named Funky's, right?
Of course,
Now, you know that people, when they're at a bar, they tend to drink sometimes, right?
yes,
You know that Taylor Drift, the passenger of that vehicle, when she was taken to the hospital, she had a blood alcohol concentration of 0.07, right?
yes,
So, Detective, you knew that the passenger of the vehicle, she had been drinking that night, right?
yes, that's correct.
Now, you know that BAC, it was only taken when she'd arrived at the hospital, right?
Right,
And you'd agree with me, Detective, that as time goes on, a person's blood alcohol concentration, it goes down, right?
yes,
So you'd also agree with me that at the time of the accident, her BAC would have been higher, right?
Objection, relevance. Your Honor. This goes to the,
Detective, I'll ask the question again. So you'd agree with me that at the time of the accident, Taylor Drift's BAC would have been higher than what it was when it was taken at the hospital, right?
I really have no way of knowing. Her BAC wasn't taken at the time of the accident.
So, Detective, you're telling the court today that you don't know that blood alcohol concentration goes down over time?
No, I'm not. That's not what I'm saying.
So you would agree then that there was more alcohol in her body at the time of the accident than there were when she was taken to the hospital?
It's likely, but I can't know for sure.
Detective, you know that the driver of that vehicle, he was also coming from a bar, right?
Yes,
You knew from your conversations with Harley Dennis that that driver, he had been drinking too, right?
yes,
Detective, you'd agree with me that sometimes when people drink, then their coordination isn't as good, right?
sure.
You'd agree with me that sometimes when people drink and they get behind the wheel, there are accidents.
Sometimes.
Detective, in your entire investigation, you interviewed as many people as you could, right?
Yes,
You tried to find anyone who could have seen what might have happened, right?
right.
You'd agree with me, you did a thorough investigation, is that right?
Yes, I did.
Detective, you never found anyone who saw Jolene Tremont puncture any of the tires, right?
No, and that's exactly how she intended it. Like I said, she had the opportunity to puncture the tires when she was outside alone, waiting for the Uber. She didn't intend for anyone to see her. That's why I couldn't see anyone.
Detective, bringing you back to my question though, you never saw anyone, you never talked to any eyewitness who saw Jolene Tremont do anything to Jacob Tremont's truck, right?
Right,
And you'd also agree with me, Detective, that you don't have any eyewitnesses who even saw Jolene Tremont holding a knife.
that's correct.
Thank you, Detective. No further questions, Your Honor.
All right.
briefly direct, Your Honor. Detective, opposing counsel just ended on a knife. You talked to Ms. Dennis about that knife. What did she tell you about that knife?
Yes, Ms. Dennis let me know that the knife disappeared from the bar. It had been sitting right in front of where Jolie Tremont was sitting. Ms. Dennis walked away for a brief period of time, came back, Jolene had stormed away, and the knife was missing.
Now, detective, opposing counsel just made a big deal about the airbags. But on the scene of that crash, you checked out that truck. What was suspicious about the truck?
Right, all 4 tires had been slashed. And like I said, there was crash damage on the front right of the truck. In my experience, all 4 tires don't just magically become slashed when a truck hits a immobile object like that. Additionally, the headlight was busted on the left side of the truck, and that did not make contact with any object during this crash, so that indicated foul play.
No further questions.
All right.
May the witness be excused.
Yes, free to go.
Your Honor, the defense would like a recross of this witness.
At this time,
Yes, Your Honor, very briefly on one point that was brought up on redirect.
Your Honor, the witness has been excused by the court.
denied.
Yes, Your Honor.
Your Honor, the prosecution calls this next witness, Harley Dennis.
Dennis.
Yes, sir.
Good afternoon, Ms. Dennis.
Good afternoon.
Before we get started, I would like the jury to get to know you a bit better. Please introduce yourself to the jury.
Hi, my name is Harley Dennis.
Ms. Dennis, were you subpoenaed to be here today?
I was.
And why did we need you here today?
I guess it's to tell the jury about what I saw the night at the bar that Jacob died that night.
And what bar is that?
Funky's Bar. I work there.
Where's Funky's Bar located?
So it's on the outskirts of town, just, a local bar, local dive bar
And what town is that?
in Oxford.
You mentioned that this is a local bar. Are you familiar with the people that come into the bar?
Oh, absolutely. It's a small town and I work there almost every night, basically. So I get to know the customers pretty well.
Can you describe the inside of the bar to the jury?
Yeah, absolutely. It's like any other bar. You have your bar, your tables, you have your pool tables. And it's not really lit that well. It's actually kind of shady.
Let's talk about the defendant. Do you know the defendant?
Yeah, I do. I've seen her around and I know her husband pretty well too.
Has she ever been in the bar before?
Well, it's a small town, so I'm sure she's been there at some point.
Was she there the night Jake died?
Yeah, she was, and I'll never forget the moment that she came into the bar that night.
Well, why won't you forget it?
Well, she looked strange.
Objection, Your Honor. Improper lay witness opinion and irrelevance. This witness's opinion on whether or not the defendant looks strange makes no effect in this case, more or less likely.
Overruled.
Yes, Your Honor.
I'll repeat it for you. Why will you not forget her coming in?
So like I said, she looked a little strange. She's typically got her hair teased, a signature red lip on, a cute outfit. But this night she came in dressed in all black, sunglasses, and I thought that was pretty weird.
Well, where did she sit?
So like I said, the bar has some shady spots, and she went and sat at the end of the bar in one of those shady spots.
What was she doing?
She just ordered a drink. She was shooting whiskey. And I see her as a spritzer kind of girl, but she was shooting whiskey that night.
When did Jake and Taylor make it to the bar?
So They came in, it was a little after Jolene. Jacob came in with someone that I had never seen before, and I won't forget that either.
Why won't you forget her coming in?
Well, she was a sight for sore eyes, to say the least. She had bangles up her arms, a crystal necklace, and she had parachute pants on, and I haven't seen parachute pants in a long time.
What did the defendant do when she saw them?
Well, everything was kind of normal. She ordered a drink, and she asked me where I kept my baseball bat at.
And what happened after that?
I didn't tell her where it was at. In fact, I told her that it was probably time for her to go home.
What happened?
Objection, Your Honor. Hearsay to this witness's statement to Jolene Tremont.
What's your response?
Your Honor, I'll ask her to rephrase.
You did what?
I will ask her to rephrase.
I'm gonna sustain the objection.
Move to strike, Your Honor.
You may.
What was your impression of the defendant after she asked you where the bat was?
Well, I got the impression that she didn't want to leave quite yet.
Did she say anything after she asked where the bat was?
Yeah, she said that she wasn't ready to leave yet because she wanted to treat Taylor Drift's face like a home run.
Objection, Your Honor. More prejudicial than probative. May I be heard?
Yes.
Now, Your Honor, in today's case, Jolene Tremont is on trial for the death of Jake Tremont, not Taylor Drift. Now, this statement regarding how Miss Tremont felt about Miss Drift, that would just simply go to inflame the passions of the jury and confuse the issues in today's case.
What's your response?
Your Honor, this is a statement against interest.
What was the statement?
Statement was that she wanted to treat Taylor Drift's face like a home run derby.
I'll sustain the objection.
Is Your Honor, move to strike.
Yes. You may proceed.
What happened after you discussed the baseball bat?
Well, everything kind of settled. And at one point, Jacob got up to go to the bathroom, and he came back. The whole bar could smell him. He smelled very strong like cologne.
What did the defendant do when he came back?
She ordered another drink, another shot, and then she went and confronted Jacob.
Well, what did you see?
I saw her go up to the table and scream very loudly that, how could you do this to our family, and stuff like that. And, it made me kind of feel bad for her, just because my mother was caught, or my father was caught cheating on my mother in about the same way.
I'm sorry for that. What happened after she confronted Jake?
She left and she stormed out of there like a bat out of hell.
When did she leave the bar?
It was 12:05.
Well, that's a very specific time. How do you know that it was 12:05?
I remember specifically because, like I said, the whole thing made me think of my mother. So I texted my mom at 12:05 just to check in on her.
When did Jake and Taylor leave the bar?
Well, it had to have been at least 15 or more minutes afterwards, because after Jolene left, they came up and ordered a few more drinks, and Taylor Drift had been ordering fruity drinks all night, and that's not really my style. And she had ordered another drink that I didn't know how to make. So I spent 15 minutes looking up ingredients and gathering it, and, it couldn't have been, it had to be a little longer than 15 minutes.
Referring court and counsel to already admitted Exhibit 4. Your Honor, permission to publish Exhibit 4. It's already been published. Thank you.
Your Honor, permission to reposition myself.
Dennis. Let me see. This is something that's already been admitted today. It's a piece of evidence. It is the receipt of the Uber that Jolene took home from Funky's bar that night.
Objection, Your Honor. Counselor's testifying.
Technically, you're right, it's a stay.
Move to strike, Your Honor.
Okay.
Ms. Dennis, can you confirm that 1107 Van Buren Avenue is the address of Funky's?
Yep, that's the address to the bar.
I need you to look this over for a second. What time does this receipt say right here?
It says 12:15.
How many minutes was it from the time the defendant left the bar to the time right here?
Well, I remember she leaving and me sending that text to my mom, and that was at 12:05. And this is 12:15, so 10 minutes.
And for the time you saw her leave the bar to the time on this receipt, did you see her back in the bar at all?
Nope, I never saw her come back in.
Thank you. Now, Ms. Dennis, that was a lot of information. Do you think it would help the jury if we built a timeline?
Yeah, absolutely.
Your Honor, permission for the witness to step down for purposes of building a demonstrative?
Right.
Come on.
Your Honor, at this time, I would raise an objection. We weren't shown this demonstrative prior to trial.
All right.
Your Honor, I can remove the line if you would like to see it built all at one time.
Is that your objection?
No, Your Honor. My objection is to whatever is about to happen with respect to this timeline. Opposing counsel is under an obligation to show us any and all demonstrative exhibits that they plan to use over the course of trial, and we had no notice of this exhibit.
What we're supposed to do here? That's my fault. I'm gonna let it go. I think you can use a witness that way. It's very creative. You didn't see it before the trial. It's
Understood, Your Honor.
happened here.
All right.
It looks like a piece of modern art, right?
Yes, sir. We will be building it.
I want to know where we're going. Objection overruled. You may proceed.
Thank you, Your Honor. Ms. Dennis, we just went over a lot of information, so I'm going to ask you to help me build a sequence of events.
Okay, absolutely.
Remind me again, for the purposes of this demonstrative, what time did you see the defendant leave the bar?
It was at 12:05.
Can you add that near the middle of the demonstrative? Above it, write 12:05, and below it, write leave bar. Let the record reflect that the witness is adding a point onto the demonstrative. Above it, it reads 12:05. Below it, it reads leave bar. Ms. Dennis, remind me again, when did the defendant confront Jacob?
It was right before she stormed out, so right before 12:05.
Well, let's add a point to the line as well. To the immediate left of the leave bar mark, draw a new one, and below it write confront. Let the record reflect that to the immediate left, the witness has drawn a spot and wrote confront below it.
All right.
Can you write it a little bit bigger, please?
Absolutely.
Thank you.
Okay.
Thank you, thank you. And what time did the Uber receipt say that she got? I'll rephrase. What time was on the receipt?
It was 12:15.
Can you draw that on the board as well to the very far right?
Absolutely.
Above it, write 12:15. Below it, write Uber. Let the record reflect that the witness has drawn a point to the very far right. Above it, it reads 12:15. Below it, it reads Uber.
All right.
Thank you. Now, Ms. Dennis, this is a lot of information. Do you think that there's anything else important that needs to be added to this?
Well, at some point during the night, I did lose my knife. My knife went missing, actually.
Well, tell me more about this knife.
So I use a knife throughout for my job. I cut up limes with it for drinks. And I remember right when Jolene signaled me over, I went over there and left my knife right in front of her. And after she had left, I noticed it was missing then.
When did you notice the knife was missing?
It was right after she had left. the
Well, let's
bar.
add that as well. To the immediate right of leave bar, write knife missing. Let the record reflect that to the immediate right of the leave bar spot, a new spot has been written.
Your Honor, at this time, I'd object to lack of personal knowledge. This witness testified that she doesn't know exactly when the knife was left, and so to put it on a timeline would miss the jury.
Your Honor, she just testified that she noticed when the knife was missing.
I'm gonna
after.
allow her to put the dot there, but she can't put the exact time unless she's given a time. Because she testified as to a time.
She's not testified. She testified to when she noticed the knife was missing.
Well, the objection is sustained to that point.
Your Honor, permission to ask counsel to erase the dot.
No, I think she testified it was after they had left the bar, she noticed it.
So it's
Understood, Your Honor.
So what
overruled.
you're doing is using me to testify to the jury now, because I'm explaining to you what I just saw.
Thank you, Your Honor. And when did you last see the knife?
I set it down in front of Jolene when she first came in.
Well, let's add that to the time as well, to the far left, right knife bar. Let the record reflect that the witness is drawing a spot to the very far left, below which it reads knife bar.
All right.
Now, Ms. Dennis, for the purposes of this, help me notice how long it was from the time you saw her leave the bar to the time on that receipt.
So like I said earlier, it was 10 minutes.
Let's add that to the timeline as well. Above the timeline in red, draw a bracket, starting at 12:05 and extending to 12:15. Inside of the bracket, write 10 minutes. Let the record reflect that the witness has added a bracket above the demonstrative in red. It is extending from 12:05 to 12:15, above which it reads 10 minutes.
All right.
Your Honor, permission to preserve this exhibit for purposes of close and appeal.
You may.
Thank you. Your Honor, you may sit back down. Ms. Dennis, before we're done, I want to spend a little bit more time on this knife. What type of knife was it that went missing?
It was a paring knife.
What do you use this knife for?
I use it at the bar to just cut up limes, things for drinks.
Do you normally use a knife at work?
Yeah, I normally use just one knife at work.
How many knives did you use the night that Jake died?
The night that Jacob died, I had to use 2.
Why did you have to use 2?
Well, my first knife went missing.
And when did you notice it was missing?
I noticed it went missing. It was after Jolene had left the bar.
And where did you last see that knife?
I set that knife down in front of Jolene when she first signaled me over.
Now, Ms. Dennis, just to be clear, has that knife been found or is it still missing?
No, it's still missing. It hasn't been found.
Thank you, Your Honor. I pass the witness.
All right.
Your Honor, I'd ask if I may use opposing counsel's timeline for
You
cross-examination.
certainly might.
And more specifically, Your Honor, if I may be allowed to draw on,
I think you should. It's your turn.
Your Honor, it's been preserved for appeal
It
and for
has.
closing.
It's gonna be drawed on too, because it's demonstrative.
Yes, Your Honor.
You may take a photo of it to preserve it for appeal.
How do I use it in close then?
You'll have to be clever.
All right, give me a phone.
excuse me,
I'll pretend. I'm gonna click. Counsel, thank you.
You may proceed.
Yes, Your Honor. Ms. Dennis, my name is Justin Gillette, and I'm going to be asking you a few questions today.
All right,
Now, I'd like to start with this timeline that you helped draw a few minutes ago.
sure.
Now, first, I'd like to start by talking about this knife. Now, we have this dot here after 12:05,
Mhm.
but you don't know exactly when this knife went missing, right?
No, I don't know exactly when it went missing.
Now, and you testified a few moments ago that the last time you saw it, it was in front of Jolene Tremont, right?
That's right.
But to be clear, Ms. Dennis, you believe you just misplaced your knife, isn't that right?
At the time, I did think that I had misplaced it.
So that's a yes to my question. You believe that you just misplaced your knife.
Right at that time, yes.
Now, I'd also like to talk about another piece of evidence in today's case. Now, you testified earlier that Jolene asked you about a bat, right?
Right.
And so that bat was in your bar before 12:05, right?
Yeah, that's right.
And to be clear, you didn't tell Jolene where that bat was, did you?
No, I didn't.
Your Honor, let the record reflect that I'm marking the timeline with bat in bar before 12:05.
So it was.
And Ms. Dennis, you obviously didn't hand that bat to Ms. Tremont, did you?
No, I didn't.
Right? And now you never saw Jolene touch that bat, right?
No, I didn't see her take it or touch it.
And so to your knowledge, you kept that bat by the back door of Funky's, right?
That's right.
So to your knowledge, that bat was at the back door of Funky's, right?
To my knowledge, yes.
For the entire night.
Yes.
And now you were asked questions by police officers in this case, right?
I was.
And you actually gave a police officer in today's case that bat, right?
I can't remember if I gave it to them, but
Is it your testimony that you did not give police officers a bat?
no, I just can't remember.
Your Honor, you would recognize a copy of that bat if it were presented to you in today's case, right?
Right, yeah, absolutely.
Your Honor, I'll be approaching, or permission to approach opposing counsel and the witness in turn with what has been previously marked as Exhibit 3. And would Your Honor like a copy?
You're fine.
Now, Ms. Dennis, I just handed you a photo of your bat, right?
Right, this is a photo of my bat.
And it's a fair and accurate copy of the bat that you kept by the back door of Funky's bar, right?
Yeah.
Your Honor, at this time, the defense moves Exhibit 3 into evidence
Any objection?
No, Your Honor.
All right, that'd be it.
and permission to publish, constructively publish to the jury.
Everybody.
Your Honor, let the record reflect. I'm marking the timeline. Just to indicate that the bat was in the bar past 12:15.
And we'll show that you're using blue ink.
Yes, Your Honor. Now, I'd also, Ms. Dennis, I'd like to talk about the interaction that you saw happen between Jolene Tremont and Jacob Tremont.
Okay.
Now, as you testified earlier, Jolene was the first to arrive, right?
Yep, she came in alone.
And she sat at your bar, right?
She did.
And she was there for a while before Jake and Taylor Drift arrived.
Right, yeah, she was there for a minute or two before.
Now, when Miss Drift and Mr. Tremont arrived, Jolene didn't go right over to confront them, did she?
No, she didn't.
Some time passed between when Miss Drift and Mr. Tremont arrived and when Jolene went over to confront them, right?
Yeah, some time had passed.
And when Jolene went over to confront them, all she did was talk to them, right?
Well, it was more like a scream and she caused a big scene, but yeah, she was talking to him.
That's right. She said, "How could you do this to our family?" Isn't that right?
Yeah, she said that.
Now, at no point in that interaction did you feel the need to intervene, did you?
No, I'm a professional first. I had a job to do.
But that's a yes to my question. You never felt the need to intervene in this altercation.
No, I didn't.
And you have intervened in altercations in your bar before, right?
Objection, Your Honor. Improper character evidence.
How's that character evidence?
Your Honor, I apologize. I withdraw the objection.
Okay, you may proceed.
I'll re-ask the question, Ms. Dennis. You have intervened in altercations before, right?
Yeah, sure, I work at a bar. Things get rowdy.
And one of the altercations that you intervened in was when a young woman was being harassed, right?
Yeah, someone has to look out for the girls.
And to be clear, you used your bat to intervene, right?
Objection, Your Honor, relevance.
Overruled, you have to say we're on cross-examination.
So to be clear, you used your bat to intervene in the past, right?
Yeah, he was harassing, the patron was harassing some girls and he wouldn't leave and he shoved me and I used my bat.
You also testified earlier about something in your past that made you feel, it's something in your past, right?
Right.
You testified that your family, your parents, one of them cheated on another one, right?
Yeah,
And ever since then, you would agree with me that you've held an extreme anger towards people who cheat.
yeah, I definitely don't like it.
But that's a yes to my question. You hold an extreme anger, right?
Yeah,
And now you saw Jacob Tremont cheating on Jolene Tremont in your bar on the night of October 20th, didn't you?
yeah,
And you'd agree with me that you were furious at Jacob Tremont on that night.
I was very disappointed in my friend, yeah.
Now, I'd like to be very clear about these two objects that we have on this timeline. Now, the knife that we mentioned, that's your knife, right?
It was my knife.
And you touched that knife, right?
I
On the
did.
night of October 20th.
I did.
And you never saw Jolene touch that knife.
I didn't.
And again, this is your bat, right?
Yeah,
You keep it by an employee door.
yeah, I keep it in the back by the door.
And you keep it there so that you can get it, right?
Yeah, sure, but what's to say someone didn't come in the back door and get it?
Well, I'm not asking you to speculate about anyone coming in the back door and getting the bat. All I'm merely asking you about is you keep this bat for you, right?
Yeah,
You don't keep it here so that patrons can come and grab this bat.
no, you're right.
You keep it in case you need to defend yourself or a patron in your bar, right?
Yeah, in case the situation were to come up.
You know, I'd also like to talk about something that Jacob Tremont was doing on the night of October 20th. Now, Funky's is a bar, right?
It is.
And you're its bartender.
I am.
So you were serving drinks on the night of October 20th, right?
Yep, that's my job.
You were serving them to Jacob Tremont.
Among others, but yes.
And Jacob Tremont was drinking bourbon on the night of October 20th, right?
Right.
You'd agree with me that bourbon is hard alcohol.
I would.
You allowed Jacob Tremont to leave your bar, right?
I can't control Jacob Tremont.
Well, you didn't take his keys, did you?
No, I can't control Jacob Tremont.
That's a yes to my question. You let him leave and you didn't take his keys.
That's a yes, yeah.
Now, I'd like to talk about one other very specific moment. Now, let the record reflect that I'm going to draw a separate timeline. I'd like to talk about what you did on this night.
Okay.
Now, after Jolene left the bar at 12:05, Jake Tremont and Taylor Drift came up to your bar to order a drink,
I
right?
did.
Taylor Drift ordered a screwdriver.
She did.
Now, you claim at the time that you didn't know what a screwdriver was. Is that right?
Yeah, that's not really the speed of the bar.
But you know now that a screwdriver, it's orange juice and vodka, right?
I do know now.
So you'd agree with me that it's a pretty simple drink.
Yeah, I would agree it was pretty simple.
Your Honor, let the record reflect that I'm marking a time after 12:05 at which Taylor Drift ordered a screwdriver.
All right.
And so because you didn't know how to make a screwdriver, you claim you didn't know how to make a screwdriver at the time, you claim that you stepped out of the bar at this time, right?
Right.
Now, to be clear, you're a bartender,
I am.
and you've been a bartender for a while.
I've been a bartender at 2 places. Yeah.
You bartend every night, right?
Yeah.
Your Honor, let the record reflect I'm marking the timeline to indicate that Harley Dennis left the bar. Miss Dennis, when you left that bar, you left out the back door, right?
Objection, Your Honor, relevance.
Overruled.
May I respond, Your Honor?
You may.
Your Honor, I have reason to believe that he's about to allege that she took a baseball bat and hit his truck. There's been no allegation or any reference to the baseball bat being used on this truck at all.
What's your response?
Well, Your Honor, we have heard testimony about the damage to the truck. We heard that both of the headlights were smashed in, but only the front right side made contact with the trees. Now that comes from the testimony of the detective.
Your Honor, there's been no reference to what was used to hit the other headlight.
Well, Your Honor, if I may.
Anything about headline. This is cross-examination. There's usually wide leeway given, but in this instance, there's been no previous testimony about a headlight that I recall. There was a picture. There was a picture of an accident of a truck.
Would you like a copy of it, Your Honor?
Such a big one you put up
Yes,
there.
sir. I can give you a small copy of it, if you would like.
Let me see your small copy.
Yes, Your Honor.
We'd like a smaller copy.
Yes, possibly.
Instead of using the one.
Yeah.
There you go, Your Honor.
I see.
Your Honor, if I may.
This picture, it looks like a headlight would be damaged.
Your Honor, if I may.
Yeah,
If opposing counsel is willing to stipulate that Jolene Tremont didn't bash in a headlight, then I'm willing to proceed.
I see.
We have no argument.
You agree
We
with that?
stipulate.
All right, thank you very much.
Thank you, Your Honor.
You may proceed.
So you claim that you left the bar to figure out how to make a screwdriver, right?
Right, like I said, that's a screwdriver, fruity drinks. They're not really the style or pace of our bar. It's more beer and whiskey, that sort of thing.
And you were outside of your bar for 15 minutes. Isn't that right?
Yeah, it took me 15 minutes to look things up.
Your Honor, let the record reflect I'm marking the timeline to say 15 minutes. So let's be very clear, Ms. Dennis. It took you 15 minutes to figure out how to put vodka in orange juice.
Yeah, I'm not the best bartender. Yeah, I did.
So just yes or no, Ms. Dennis. It took you 15 minutes to figure out how to put vodka in orange juice.
Yeah.
No further questions at this time, Your Honor.
All right. You want to take exhibit next?
Yes, I would like to take it down. Your Honor, may the witness be excused.
Yes, you bring it up. Who would you call next?
Your Honor, at this time, prosecution rests this case.
All right, prosecution is arrested. What says the defense?
Your Honor, at this time, the defense would like to make a motion under Federal Rule of Criminal Procedure 29, a motion for judgment of acquittal. It may be heard.
You may.
Well, Your Honor, we have heard no testimony today that one of the elements in today's case is jurisdiction. We have not yet heard exactly where the accident took place, whether it took place in this county's jurisdiction, in Lafayette County. And on that ground, as well as on the ground of causation, which is required in order to show second-degree murder, which we have not heard enough evidence to make out a prima facie case. We've heard no testimony specifically describing how slashes in the tires would cause the car to careen off of the road and into the trees. And we've also heard additional testimony regarding the alcohol that the driver of that vehicle had consumed. So a reasonable jury member could not conclude beyond a reasonable doubt that the accident was a result of the slashes in the tires.
All right.
May I respond, Your Honor?
Yeah, you.
It's a very low bar. All it needs is a reasonable jury to have a considerable evidence to say that we, to opposing counsel's first point, we have established a venue. It was testimony from Detective Seymour, who said she arrived on the scene at County Road 31. I asked her exactly where was County Road 31, and Detective Seymour responded with Lafayette County. As it goes to jurors are allowed to make reasonable inferences. As it goes to slashes in a tire causing an accident, that is an inference that a reasonable jury could make at any time, Your Honor.
All right. Well, it's a mighty close case, but it would seem terribly unfair
It would be, Your Honor.
to not hear the other side.
Yes, it would, Your Honor.
I'm going to deny your motion.
Yes, Your Honor.
All right. Are you ready to proceed?
Can we have like a 7-8 minute recess, y'all?
Okay. Any problem with that?
Nope, we're going to pull that.
Let's all take about a 10-minute recess.
Thank you, Your Honor.
Hey, Katie, or is anybody there that can hear me?
Yeah, as soon as he started saying, I was like, I wrote it on my notes. I was like, oh, Ms. Dupree, if you wouldn't mind sitting in that other seat.
Sorry.
May I proceed?
You might.
Could you introduce yourself to the jury?
My name is Casey Dupree.
Ms. Dupree, what do you do for a living?
I'm a fourth grade teacher. I absolutely love my job.
I want to bring you to why you're here today. Why are you testifying?
Well, I know both Jolene Tremont and the late Jacob Tremont. And I also know the bartender who was at the bar.
Ms. Dupree, I want to start with that bartender. Who is you?
Harley Dennis. Harley is a really good friend of mine. Great pal, very, very good at listening, always there to lend a helpful hand. And I mean, sometimes a bit too helpful, even.
What do you mean sometimes she's a bit too helpful?
Well, she can get pretty defensive, pretty protective when she notices that other people are being disrespected.
Ms. Dupree, have you ever noticed this happening for you?
Yeah, I do remember feeling like, wow, she really cares about me, very, very protective. One time I was at a bar and some people got a little inappropriate, they got a little handsy. And she just got really worked up, really, really frustrated with them.
Ms. Dupree, you also mentioned that you know the Tremonts. How do you know that?
Well, I've been best friends with Jolene Tremont since college, and I've known Jake Tremont for a while now.
Ms. Dupree, I'm going to ask you some questions now, but about the night that Jacob passed away. If you need a moment, please let me know. Did you get a chance to speak to either Jolene or Jacob that night?
I did get the chance to chat briefly with Jolene. You know, I wish I could have been there and made sure that, you know, Jake was safe that night too, but unfortunately I didn't talk to him.
I want to ask you some questions then about that conversation you had with Jolene. What did you talk about?
Well, she called me spitting mad. She had just found out about her husband's affair. Honestly, I don't blame her. She was screaming, crying. It was pretty intense.
Ms. Dupree, was she mad the entire call?
Oh no, you know, I did what a best friend does. I let her vent. I affirmed her, made her feel like someone was listening to her, and she was calm by the end of the call.
Ms. Dupree, I want to be very clear for the jury. Did you ever mention this phone call to the police?
No, I didn't.
In that phone call on the night of the accident, did Jolene ever mention anything about a knife?
No, definitely not.
Did she ever mention anything about Jacob's truck?
No, she didn't.
Miss Dupree, was she still, you mentioned that she was calm at the end of that conversation. Why did you hang up?
Oh, well, I actually didn't hang up. She hung up because she told me she was scared. Objection relevance?
I could understand what she said.
Your Honor, would you like the witness to repeat it or should I?
What did you say? Because
She was scared.
okay.
Or she told me that she was scared. I think that's what I said.
May I respond, Your Honor?
Yes.
Your Honor, it's the defense's contention in this case that an alternative suspect for who slashed those tires is Harley Dennis, the bartender, and the second witness from the state. And if I may proffer, Your Honor, the witness in subsequent answers will explain that at the end of this phone conversation, Jolene Tremont was scared because she had just seen the bartender leave the bar with a bat.
Okay.
Your Honor, may I respond?
Well, yes.
Your Honor, we've already stipulated that Jolene did not hit the lights with the bat, and we've already kept out the information about him walking out of the back door with the bat.
I don't know how's that inconsistent? What you're bringing out. Have you stipulated to this?
Your Honor, we did stipulate that Jolene did not hit the truck with a bat or in any way use that bat against the truck. However, Your Honor, it was not the defense's stipulation that Harley Dennis, the bartender, did anything with the bat and that truck. And that's what we're exploring right now.
Is that correct?
Your Honor, I believe that is his argument.
Okay, overruled. You may proceed.
Thank you, Your Honor.
Ms. Dupree, you had just said that Jolene said she was scared. Do you know why she said she was scared?
Yeah, she said that she had to hang up because she was scared and she had just seen someone leaving the bar with a bat.
Do you know who that person was that she saw leaving the bar with a bat?
Yeah, I do.
Who was it?
Harley Dennis.
Objection, hearsay.
May I respond, Your Honor?
Yes.
Your Honor, this falls under an exception to hearsay, both exceptions to hearsay, both 803.1 and 803.2. A present sense impression and an excited utterance. As the witness has already explained, this is a conversation happening between this witness and Jolene Tremont, the defendant. At the time that she perceived the bartender leave the bar with a bat, the witness has described how Jolene said she was scared, how she was going to hang up because someone had just left the bar with a bat. Your Honor, this satisfies both an excited utterance and a present sense impression.
All right. What's your response?
Your Honor, this testimony is being offered for the matter of,
the
offered for the
truth
truth of the matter
asserted.
asserted, yes.
Well, I didn't know she was on the phone observing this. That's what she said at the time it occurred.
Yes, Your Honor.
Your Honor, it's my understanding that the witness was on the phone with the person who was observing it. So the witness did not observe this herself.
Yeah, but she's telling, I think it was an excited utterance. I think it's an exception.
Thank you, Your
You
Honor.
may proceed.
Ms. Dupree, did Jolene Tremont say who she saw leaving the bar with a bat?
Yes, she did. She said it was Harley Dennis.
Thank you, Ms. Dupree. No further questions.
All right. Any cross?
Yes, Your Honor.
You may proceed.
Thank you.
Good afternoon, Ms. Dupree. I want to begin by clarifying the nature of your relationship with Jolene.
For sure.
You testified today that you're best friends with Jolene, correct?
I am.
And you've been friends for a long time,
Since college, yeah.
and friends help friends, right?
Absolutely. That's the purpose of having friendships.
And Jolene has helped you before, right?
Yeah, she has. I've helped her too.
She helped you get out of a driving under the influence ticket?
Yeah, she made some calls and the DUI went away. The citation went away.
It was 2020, correct?
No.
We'll move on. Sorry, it was 2020?
That I got the citation?
Yes.
No.
Okay, we'll just move on. It was a Tuesday night, correct?
Yes, it was.
Tuesday night's a school night, correct?
Yeah.
And you're a school teacher?
Yes, I am.
You teach the 4th grade
Yes, I love my kids.
for 9 years.
Yes.
And you work on school days, right?
Yeah, of course.
Wednesdays, for instance?
Of course.
So you were at the bar on the night that you got the DUI, correct?
Yeah, I was.
And you left. You drove,
I did.
got pulled over,
Mm-hmm.
and got a ticket.
Citation.
And Jolene helped you out, right?
Yeah, she did.
She made a few phone calls,
Mhm.
made everything disappear,
Made the citation disappear, yeah.
right? And you didn't suffer any consequences, right?
Yeah, not as a result of that.
And now you're here
Yeah.
today, testifying for Jolene.
Yeah.
Thank you. Let's talk about what happened on the night that Jake died. Jolene called you, correct?
She did.
Because you weren't there.
I wasn't there at the time, though.
And she was angry.
Yes, I would say so.
She was hurt.
Yeah.
And she said she wanted Jake to hurt, right?
Yeah, she had just found out about the affair. She was really emotional. I think all of us would be in that situation.
She wanted to make him hurt.
Yeah, I think she was venting, but yeah, that is what she said.
And then she got off of the phone, right?
Yeah, after we had a conversation.
And she went home.
That's what she told me she did, yeah,
And she texted you
yeah,
and told you that you were a good friend, right?
yeah,
And asked you not to tell anyone that she was there, correct?
yeah. I think she was really embarrassed, in a small town. People finding out about a confrontation like that would be really embarrassing.
But to be clear, she was there, right?
Yeah,
You didn't see anything that night, did you?
no, I didn't.
You weren't at the bar?
I wasn't at the bar presently. or
You-
physically.
I apologize. You didn't see Jolene?
No, I didn't. Just talked on the phone.
You didn't see Jake?
No.
His date?
No,
Did you see her take the knife,
no,
leave the bar?
no, I didn't. I didn't see anything, but she told me about leaving the bar, all the things that happened
Right.
between her husband and and his date. Yeah,
You didn't see her outside?
no,
You didn't see her call an Uber?
no,
You didn't see her slash his tires?
yeah, absolutely not.
You didn't see her out there alone?
No,
You didn't see her get in her Uber?
no,
But it was your testimony today that you said, I wish I could have been there, correct?
yeah, of course.
But to be clear, you were not there that night, right?
No.
Thank you, Your Honor. No further questions at this time.
All right.
Your Honor, the defense does not have a redirect.
Okay,
We'd ask that this witness be allowed to step.
all right, free to go.
Thank you.
Who'd you call next?
Your Honor, the defense calls Dr. Jordan Huntsman. Permission to proceed, Your Honor.
You might proceed.
Can you please introduce yourself to the court?
Certainly. Good afternoon. My name is Dr. Jordan Huntsman.
What do you do for a living, Dr. Huntsman?
I am a crime scene specialist.
What is a crime scene specialist?
Crime scene specialists physically examine crime scenes. We look at different data points and evidence that's collected at crime scenes to try to figure out what happened at those scenes and to help solve crimes. Sort of like what you see on CSI.
What's your educational background?
I have a bachelor's degree in physics and a PhD in physics, both from NYU.
After receiving your PhD in physics, what did you do for work?
I worked at the FBI for 10 years as a crime scene specialist.
And what exactly did you do while you were working for the FBI as a crime scene specialist?
So I spent my time at the FBI focused on analyzing data, just as I mentioned. I would collect data from crime scenes and use it to recreate the scenes of those events. I would put that data into different mathematical models and use the laws of physics to run simulations to help figure out what happened at different crime scenes.
Do you still work for the FBI?
No, sir, I do not.
Who do you work for now?
Well, right now I run my own consulting company.
What does your consulting company do?
My consulting company is also a crime scene specialist type of consulting company.
Have you ever testified in court before?
I have, yes.
And how many times have you testified in court?
I've testified 66 times in court. That includes both for the prosecution and for defendants.
And are you a member of any professional organizations?
Yes, I am. I'm a member of the Scientific Working Group for Crime Scene Investigation. That is a specialist group of crime scene experts who all have advanced education.
Your Honor, at this time, the defense tenders Dr. Huntsman as an expert in crime scene investigations.
What says the government?
No objection, Your Honor.
All right, if it's so accepted, you may proceed.
Dr. Huntsman, I'd like to talk about the work you did for today's case. Now, first, what were you asked to analyze in today's case?
I was asked to analyze the circumstances and corresponding police investigation into Jacob Tremont's death in order to figure out whether the damage to the tires on Mr. Tremont's truck is what caused either his crash or his subsequent death.
How much were you paid for your work in today's case?
I was paid a total of $40,000. That's $250 per hour for 35 hours and my travel expenses.
What material did you review in your analysis?
I reviewed Jolene Tremont's interview by the police, I also reviewed Detective Seymour's police report. I reviewed the autopsy report for Jacob Tremont, as well as all of the evidence that the county police department collected that related to Mr. Tremont's F-150. And on top of all of that, I did my own personal investigation of the crash.
And was all of that information sufficient to come to a conclusion in today's case?
Yes, it was.
Dr. Huntsman, what was your overall conclusion in today's case?
I concluded that the police lacked sufficient evidence to determine whether the damage to the tires on Mr. Tremont's truck caused either his crash or his subsequent death.
Dr. Huntsman, I'd like to talk about how you arrived at that conclusion. So what did you do in the course of your analysis?
So what I did is I looked at a couple of factors to determine whether or not the damage to the tires could have been the cause of his crash or his death.
What were those factors that you just mentioned that you looked to?
I looked at the immediate environmental surroundings of the crash and the manner of Mr. Tremont's death.
Dr. Huntsman, I'd like to break those down and take them one at a time. Let's start with the immediate environmental surroundings. Now, what did you find when you analyzed the immediate environmental surroundings?
So what I found and what I focused on was a deep pothole that I found in the road that was just meters away from the location where Mr. Tremont drove off of the road.
Would you recognize a picture of that pothole that were presented to you today in court?
I would, yes.
Your Honor, permission to approach opposing counsel and the witness in turn with what has been previously marked as Exhibit 1.
Right.
Dr. Huntsman, what have I just handed you?
You handed me Exhibit 1, which is a picture of that pothole in the road that I just mentioned.
And is that picture a fair and accurate depiction of that pothole and the immediate area surrounding it?
Yes, it is.
Your Honor, permission to publish to the jury. This has been pre-admitted into evidence.
No, Your Honor, it's been previously admitted.
Your Honor, permission to approach and hand it to the jury. Dr. Huntsman, what did you learn from that pothole?
Well, when I looked at that pothole, I was trying to determine whether or not Jacob Tremont's truck could have driven over it, and that caused the crash. So what I learned when I looked at the pothole was that we simply don't know whether that was the case.
And why don't we know whether Mr. Tremont's truck hit that pothole?
Well, we don't know because there was a lack of due diligence on the part of the investigating police officer, Detective Seymour.
What do you mean by a lack of due diligence?
Well, in order to figure out whether the damage to the tires, whether the truck could have driven over that pothole, we need to know things like the speed at which Mr. Tremont was driving that night, or whether or not the police collected any forensic evidence that would indicate whether the tires ever made contact with the pothole in the road.
Did any of the materials that you reviewed indicate the speed Mr. Tremont was driving in the early morning hours of October 21st?
No, sir. None of the police reports that I reviewed indicated that.
Did any of the information that you reviewed tell you that there was any testing done on that pothole?
No, sir.
All right, Dr. Huntsman, I'd like to talk about the second half of your analysis you mentioned, manner of death. What did you look at when you analyzed the manner of death?
I reviewed the autopsy report for Mr. Tremont.
And what did you learn from the autopsy report?
So I learned from the autopsy report that Mr. Tremont died when his head hit the steering wheel of his truck.
Dr. Huntsman, if Mr. Tremont's head hit the steering wheel, did his airbag deploy?
No, actually, Mr. Tremont's airbag failed to deploy in the crash.
Now, was there anyone else in Mr. Tremont's truck in the early morning hours of October 21st?
Yes, there was. There was someone in the passenger seat.
Objection, relevance.
Can I respond, Your Honor?
Yes.
Well, Your Honor, if I may proffer,
Right.
this witness is going to testify that the autopsy report said that the passenger side airbag did in fact deploy. Now, and Taylor Drift survived the accident. Now, that goes to show that there may be an intervening cause in today's case, namely the failure of an airbag on the driver's side to deploy.
May I respond?
Yes.
Your Honor, we are here today for second-degree murder of Jolene Tremont for the death of Jacob Tremont. The survival of Taylor Drift has no bearing on today's case, Your Honor. besides the fact that she was actually in a car crash with Jacob Tremont?
Have we not already heard testimony that she was in the vehicle?
Yes, Your Honor.
Overruled, you may proceed.
Dr. Huntsman, did the passenger side airbag deploy?
Yes, the passenger side airbag did deploy.
Dr. Huntsman, do you know if the passenger is still alive today?
That is correct. The passenger, Taylor Drift, did survive the crash.
No further questions at this time, Your Honor.
All right, any cross?
Yes, Your Honor. Dr. Huntsman, my name is Varian Shaw. I don't think we met.
Oh, nice to meet you.
Nice to meet you as well. Before we begin, can we just agree that you answer the questions yes or no, and then explain further so we can have an ample conversation?
I'll certainly try to.
No problem. Dr. Huntsman, you were hired by the defense here today, correct?
Yes,
And you were retained for $250 an hour,
yes,
and you've billed 35 hours preparing for today's case, correct?
yes, that's right.
So you received $8,750?
No, I received 40,000.
Okay, I'm sorry. Off for the $250 an hour and multiplied by the 35 hours you spent preparing, you billed originally the $3,750 an hour, correct?
I'm sorry, I didn't quite follow either.
I'll refrain. I'll move on. Dr. Huntsman, you also charge for hotel expenses, correct?
Yes, all my travel expenses, including my hotel expenses.
Travel expenses as well?
Yes,
And so for your hotel and travel expenses, you charge $31,250, correct?
yes,
And this brings us back to the figure that you mentioned earlier. You charge $40,000, correct?
yes,
And you developed an opinion in today's case, didn't you?
that is correct.
And you filed a report, correct?
I prepared a report. Yes,
Was it accurate?
my report was indeed accurate.
It was full.
I'm sorry.
It was a full report, correct?
Yes, it was.
It was thorough.
Of course.
And Dr. Huntsman, it was 2 pages, correct?
I think it was 3 pages long.
I apologize. It was 2 pages and 3 lines long, correct?
Yes, that's right.
Dr. Huntsman, let's talk about your 2 pages and 3 lines long report. That was $40,000 worth.
Objection, Your Honor, argumentative.
Yes, called.
Overruled.
Yes, Your Honor.
Dr. Huntsman, in your report, you said it's impossible to determine the direct result of the direct cause of the crash, correct?
That's right. In
Objection, Your Honor,
fact,
hearsay.
It's in his report, Your Honor.
Your Honor, his report is an out-of-court statement, and opposing counsel is using it to prove the truth of the matter, sir.
He's an expert, Your Honor.
He's on cross-examination. He has given an opinion. I presume the report was provided to the other side. They're entitled to ask you.
Yes, Your Honor.
Overruled.
Thank you, Your Honor. I asked again, in your report, you said it's impossible to determine the cause or the direct result of the crash, correct?
that's correct. The police simply lacked enough evidence to determine what the cause of the crash was.
You couldn't tell if it was the pothole, correct?
That's right. It certainly could have.
Or the slashed tires, correct?
Yes, that's correct.
So you don't, and also in your report, you said you don't acknowledge any evidence of foul play,
That's true.
but you do acknowledge that the tires were slashed, correct?
I did recognize that there were 4-inch long gashes in the tires. Yes.
Now, Dr. Huntsman, I don't want to take up too much of your time. I know it's quite expensive. The last thing you said you have experience in an accident or reconstructing mass catastrophes, correct?
Yes, that's right. That's what I spent my time at the FBI doing.
But your report doesn't mention any reconstruction of this crash, correct?
No, I couldn't do it. I was looking for more evidence from the police.
So just so the court and the jury gets this clear, you charged $40,000 and you did not reconstruct this crash.
No, sir, I couldn't.
No further questions, Your Honor.
All right. Any redirect?
No redirect, Your Honor. I simply ask that Mr. Huntsman be, or Dr. Huntsman be allowed to step down.
Your final excuse. Who would you call next?
Your Honor, at this time, the defense closes our case in chief. And at this time, we would re-raise our objection under Federal Rule of Criminal Procedure 29, but if Your Honor would simply like to move to closing arguments and constructively note that
Your Honor, we renew what we stated earlier. We've established venue, we've established causation. We renew our exact statement.
I'm going to overrule the motion. You made it correct. Are you ready to proceed?
No, Your Honor. Due to the demonstrative, can we have another? I know this may be a little lengthy. Can we have another 10-minute recess to set up for close?
No, we're amenable to that, Your Honor.
All right, we'll let you.
Thank you, Your Honor.
All right, court will be in recess.
would like everyone, he didn't get notice of appearance, so he'd like, besides the stand-up, state their team number and their names before we go into closing arguments and our and judgments. Okay.
Is he ready at this time?
So everyone can remain seated and court will continue.
Good afternoon, Your Honor. My name is Michael Notchnot. Together with my co-counsel, Justin Gillette, we represent the defendant, Jolene Trump.
Can you tell us your team number?
Team number 3.
Team number.
Good evening, Your Honor. My name is Varian Shaw, and this is my co-counsel, Rebecca Smith, and we are Team 1, and we represent the state.
We're ready to proceed.
Yes, Your Honor.
Yes, Your Honor.
Before we proceed, Your Honor,
Yes,
is the way the podium set up, is that fine for you?
that's fine. We can see this podium also.
Yes, sir.
You may proceed.
May it please the court, opposing counsel, and members of the jury. Hurt people hurt people. The evidence in today's case showed that Jolene Tremont discovered her husband was having an affair. She then dressed up, went to the bar, sat in the shady corner of the bar, and watched her husband go on a date. She was able to keep her cool for a good minute, and then she smelled him. She smelled his cologne, and then she lost it. She stormed up to him and his date, and then left the bar. And on the way out the bar, she grabbed a knife. And then she went in that parking lot and put a hole in each one of his tires. Good evening. My name is Varian Shaw, and along with my co-counsel, Rebecca Smith, we had the pleasure of representing the good people of the state of Mississippi. And in today's case, as representatives of the state of Mississippi, we had to prove beyond a reasonable doubt that Jolene Tremont was guilty of second-degree murder. I'll explain this further, but I want to dive into it so we understand what do we actually have to prove this evening. The state has to prove beyond a reasonable doubt that Jolene Tremont, without the authority of law, did kill Jacob Tremont, a human being without the authority of law, in the commission of an act eminently dangerous to others, and evincing a depraved heart, regardless of human life, although without any premeditated design to effect the death of an individual. Now, members of the jury, that's lawyer talk, so I'll make it quite simple. It doesn't mean that she had to plan to kill him. She just had to act recklessly and carelessly and do an act that caused the death of Jacob Tremont, her husband, the father of her 3 kids. Now, at the beginning of this trial, my co-counsel stood before you and told you should focus on 3 things: the means, the motive, and the opportunity. Now, at this time, Your Honor, I want to pause and I want to give the opposing counsel a chance to take a picture of some sort of the demonstrative before I alter it again. Is that okay? Now resume. Let's start first with the means. You heard Detective Seymour tell you how she arrived at the accident and she saw the damage that the accident caused. And then she told you the damage that caused the accident. She told you the 4 holes in each tire, how they were slashed. You then heard the bartender tell you about the knife, how it was there 1 minute, then Jolene's yelling at her husband, and then the knife is gone, except it wasn't gone. It was outside in the parking lot being stuck into each one of her husband's tires. Now, that brings us to the motive. Why would she do this? Why would she do this to the father of her 3 kids? Well, that is undisputed in today's case. She called her husband on a date. She dressed up, sat in the shady side of the bar, and watched her husband on a date. She watched him shoot whiskey. she cool, whisper sweet nothings in her ear. She was able to keep her cool. But then she thought to herself about her family, about the fact that her husband in that time thought that she was at home taking care of their 3 kids while he's out here and a night on the town at Funky's bar. She couldn't take it anymore. So she walked up to him, told him a few choice words, and stormed out. And that brings us to the opportunity. For 10 minutes, Jolene Tremont was alone in that parking lot with that truck, that brand new F-150, that F-150 that her husband loves so much, that F-150 that he loves the way he's supposed to love her. She couldn't take it anymore. Now, we had a burden to prove to you today, and we had a burden to prove beyond a reasonable doubt that Jolene Tremont did kill Jacob Tremont without the authority of law, a human being without in the commission of an act eminently dangerous to others and inventing the depraved part, regardless of human life, although without any premeditated design to affect the death of a particular individual. Now, you all have heard what reasonable doubt is. But I want to go over that slowly but carefully with the jury and illustrate what is reasonable doubt. Reasonable doubt is only when, after examining the evidence on the whole, you are able to say on your oaths beyond a reasonable doubt that the defendant is guilty and that the law will permit you to find him or her guilty. Now, that doesn't mean you have to remove all doubt, just all reasonable doubt. And you're allowed to make inferences. I'll illustrate that with the story. Let's say one day you get up, you go into your house, and it's cold outside. You go in, and you're watching, it's on the news, you're really not paying attention to the TV, and the weatherman says, hey, it's gonna snow tomorrow. You lay down in bed, go to sleep, your alarm goes off. You wake up, you step into your slippers, put on your robe. You go to let some sunshine. You open the curtains, and outside is a winter wonderland. Your driveway, your car, your lawn, the road, your neighbor's driveway, your neighbor's car, your neighbor's lawn is all covered in snow. Now, you can reasonably infer that it snowed last night. Did you see it snow? No. But you know it snowed. You know, back to this key word, beyond a reasonable doubt, that it snowed last night. Ladies and gentlemen, you could say some billionaire hired his minions and had some snow machine and put snow all over. Is that possible? I guess. Who knows these days? Is that reasonable? No. Now, I want to remind you, no one saw Jolene Tremont slash that tires, but you didn't need them to. You saw. You heard the detectives testimony today. There were holes in each bore of the tires. You heard the bartender today tell you that her knife was missing. I want to remind you, Jolene Tremont showed up at that bar before Jake. She dressed appropriately so she wouldn't be seen. I want to remind you that she watched him. I want to remind you that she was able to keep her cool until she smelled him. I want to remind you that she then stepped out the bar. I want to remind you that that knife was never seen again. I want to remind you of the 4 slashed tires. I want to remind you of everything you have heard today. The only reasonable inference today is that Jolene Tremont got upset, walked out, and slashed all 4 tires. Now, I'll have a chance to speak with you again, but before, the defense will come up here and try to sow doubt. You've seen today that they even said the bartender may have done it. Now, they made a big deal about it, but smashing a few hits with a Louisville Slugger to an F-150 doesn't cause a car to swerve off the side of the road. It's the knife and the 4 holes in each tire. And you hear them speculating, guess what was Harley Dennis's mind state at this time, but members of the jury, I want to ask you, you mean to tell me someone was at the bar tonight and saw Jacob Tremont on the day, and the person who slashed the tires in his car was not the person who has 3 kids by the man? Is that what they want you to believe? Members of the jury, you are allowed to use your common sense. No matter what the defense tells you, use it. Now I'm going to sit down for a second. I'm going to let the defense come here and poke some more holes. They may mention their expert who they paid $40,000 to give 2 pages and 3 lines. He didn't reconstruct this accident. And he even acknowledged the slashed tires. He mentioned it was a pothole. They paid a detective $40,000 to mention a pothole in a country road, on a county road. Members of the jury, there are potholes on county roads. I think we all knew that. But what they are not, brand new F-150s do not come equipped with 4 holes in each tire. Members of the jury, I will stand before you again and I will ask you again to find Jolene Tremont guilty of the second-degree murder of her husband, Jacob Tremont. At this time, may I reserve any remaining time for rebuttal?
You may.
Thank you. And do I need to remove?
Your Honor, I simply ask that the opposing counsel remove the demonstrative to the bench's left.
Yeah.
Your Honor, counsel, members of the jury, may it please the court.
You ever see?
A bitter bartender and too much booze. On the night of October 20th, 2021, Harley Dennis took a knife that she had been using to cut limes, walked out of the back door of Funky's bar, proceeded around Funky's to the parking lot, and sliced 4-inch long gashes in the tires of Jacob Tremont's car. Then Harley Dennis went back into Funky's and continued to work as a bartender. She continued to serve drinks to the decedent in today's case, Jacob Tremont. That, members of the jury, brings us to the booze. You see, that wasn't the first drink that Jacob Tremont had that night. Jacob Tremont had been drinking at Funky's all night. And then Jacob Tremont made a very regrettable decision. Jacob Tremont drove his Ford F-150 drunk in the early morning hours of October 21st, 2021. And it was that bitter bartender and that booze that caused the car accident at 1:30 a.m. on County Road 31. Members of the jury, that causation, that's reasonable doubt. You see, opposing counsel, when they brought the very serious accusation that they brought into today's courtroom against Miss Jolene Tremont, they brought with them a burden. They have to prove 3 things beyond any reasonable doubt. They have to prove that Jolene committed an act, that she slashed the tires. They have to prove that that act caused Jacob Tremont's death. And they also have to prove that Jolene Tremont acted with a depraved heart. Members of the jury, they failed to meet their burden, and they failed to meet their burden because Jacob Tremont's death was caused by a bitter bartender and too much booze. At the beginning of trial today, my co-counsel, Mr. Michael Nonchant, asked you 3 questions. I'd like to walk you through how the evidence answers those 3 questions today. He asked you, who else had the means, motive, and opportunity to slash the tires? He asked you how much Jacob Tremont had to drink that night. And he asked you what, if any, evidence actually connected Jolene Tremont to Jacob Tremont's death. Now, I'd like to start with that first question. Who else besides the defendant had the means, motive, and opportunity to slash Jacob Tremont's tires? Members of the jury, the evidence has shown that Harley Dennis had better means, more motive, and a better opportunity to slash the tires of Jacob Tremont's car. Let's start with the means. Now, the state wants you to believe, based on circumstantial evidence, that because the knife was set on the bar, that Jolene Tremont, who was at the bar, picked up the knife when it went missing and somehow, without anyone noticing, slashed the tires of the truck. Members of the jury, that just doesn't make sense. We only heard evidence about one person touching the knife on the night of October 20th. That one person was Harley Dennis. That makes sense because it was Harley Dennis's knife. It was the bar's knife, and Harley Dennis was the bartender. Now, of course, Harley Dennis would tell you that it went missing. Of course, he hid the murder weapon, or she hid the murder weapon. Now, I'd like to talk about opportunity. Now, on the direct examination of Harley Dennis, opposing counsel made a big deal about the time that Miss Tremont was outside of the bar. And they showed, based on an Uber receipt and a text message that Harley Dennis sent at the same time that Jolene left, that Jolene was outside the bar for 10 minutes. But Jolene wasn't the only person who was outside of the bar that night. You heard testimony from Harley Dennis herself that she was outside of the bar for more time, for 15 minutes. She admitted that to you on cross-examination. Members of the jury, 15 minutes is a better opportunity than 10 minutes. It's simply more time to slash the tires. Now let's talk about motive. Now, the state wants you to believe because Miss Tremont saw her husband cheating, that she killed her husband. Members of the jury, life is not as simple as a Carrie Underwood song. Jolene Tremont and Jacob Tremont, they had a family. They had children together, 3 children. They had been married for years. She didn't have a motive to kill Jacob Tremont. Members of the jury, remember what Harley Dennis told you that Jolene Tremont said to her husband and his lover on the night in Funky's bar. Miss Tremont said, "How could you do this to our family?" Our family, members of the jury. Miss Tremont was only thinking about her children. She certainly did not want to do any harm to her husband. She did not act with a depraved heart on the night of October 20th, 2021. Members of the jury, I'd like to turn to the second question Mr. Nonchalant asked you at the beginning of the trial today. How much Jacob Tremont had to drink? Now, opposing counsel is right. When you go to deliberate in today's case, you do not have to leave your common sense at the door. Members of the jury, your common sense tells you that when someone drinks alcohol, it makes it harder for them to drive safely. Members of the jury, you heard evidence today that the decedent in today's case, Jacob Tremont, he was drinking bourbon in Funky's bar that night. And you know that bourbon is hard alcohol. You know that bourbon would make it very difficult to drive home safely. And you heard that Mr. Tremont, after drinking that bourbon, did get in his car and he did attempt to drive home. You also heard that at a certain point, he may have hit a pothole. And now we've all hit potholes in our lives, right? And we know that when you hit a pothole, your car doesn't necessarily veer right off the road, right? When you get a flat tire, your car doesn't necessarily veer off the road. But when you're drunk, members of the jury, it might be more difficult to control your car. The alcohol the pothole, those two things caused Jacob Tremont to swerve off of the side of the road. Those two things caused his death. I'd like to talk about that third question that Mr. Nunchin I asked you. What, if any, evidence actually connects Jolene Tremont to the truck? Now, opposing counsel wants you to believe, once again, that it was this knife. Did they show you a knife, members of the jury? At no point in today's trial did they show you the knife that they claim was essentially the murder weapon in today's case. They also presented no evidence about how those slashed tires actually caused the accident. They did not prove beyond a reasonable doubt that it was the slashes in the tires, rather than the airbag that failed to deploy, rather than the pothole, rather than the driver's intoxication that caused the accident. Now, opposing counsel, he made a metaphor to explain circumstantial evidence. He said that if you find piles of snow on the ground and all of these other pieces that might suggest that it snowed, you don't necessarily need to see snow falling from the sky to know that it snowed. Members of the jury, you don't have piles of snow in this case. At most, you have a puddle. Members of the jury, there's a lot of explanations for how a puddle might get on the ground. Could have rained, snow could have melted, someone could have spilled their water bottle. In today's case, Harley Dennis could have caused the death. The pothole could have caused the death. Alcohol could have caused the death. The failed airbag, the airbag that failed to deploy, could have caused the death. If you believe that any of those things likely caused the death, members of the jury, you have reasonable doubt. If you have reasonable doubt, members of the jury, you cannot convict Jolene Tremont. So because a bitter bartender and too much booze were the cause of Jacob Tremont's death, I ask that you find my client, Jolene Tremont, not guilty. Thank you.
May I rebut now? Members of the jury, this may seem kind of easy, but I told you so. I told you exactly what the defense was going to do. A bitter bartender and a lot of booze, or whatever it was. Members of the jury, the defense just got up here and said that Harley Dennis, the bartender that night, had more motive to harm Jacob Tremont than his wife, who caught him cheating in a bar. They said she had more opportunity, more means. Well, like I said, that knife was never seen. And more importantly, why would Harley Dennis commit such an act and then walk back inside? You know who may have committed that act? The person who got in the car and left, who went back to her kids, her family, the person who was married to the person who's deceased today. They also mentioned a lot of booze, and members of the jury, I can't testify to that, but you know who else can't testify to that? Jacob Tremont. You did not get to ask him how much he drank that night, because he's not here. More importantly, his wife could, you know, carve the mean message in his brand new F-150. She could have ripped the upholstery out, but instead, in the thick of the night, she got down and poked a hole in each one of his tires. Members of the jury, that's a hidden danger. Carelessly and recklessly. Members of the jury, sure, if she would have just keyed a mean message, sure, Jake would have been upset, he would have been angry. You know what he would be though? Alive. Members of the jury, they mentioned this big deal about a bag, but we know that the tire exploding is what caused the wreck. Now they mentioned a pothole, and they fixate on this pothole. And it is a hole that is pretty deep in this case, but it's actually 4 holes that are pretty deep. It's the holes in each one of Jake's tires. A pothole on a county road is not reasonable doubt. More importantly, they mentioned his booze and how much he drank that night, even though you did not get a chance to hear him testify to that. But more importantly, driving on 4 slashed tires would kill anyone sober. Had one tire happen to deflate and then you veer off the road and crash into a thicket of pine trees. They mentioned the 15 minutes that Harley Dennis was at the bar. Do you think she would commit such a crime like this and then walk back into work? Or should we talk about the 10 minutes that the wife spent alone, upset, in a parking lot with her husband's new truck while she was supposed to be at home with her 3 kids? Members of the jury, the defense just badly recollected a story that I had about a puddle or whatever he should call it. Members of the jury, he said, I illustrated reasonable doubt using the snow story, that if you see snow on the ground, short story, if you see snow on the ground, you can assume with beyond a reasonable doubt that it's snow. And he said, you have puddles of water. Well, members of the jury, I bring you back to the attention to the means, which is the knife that was never seen again once it was placed in front of Jolene. The motive, which I think is pretty obvious here. And the opportunity, these 10 minutes that Jolene spent alone in that parking lot, upset, thinking about her kids, her family, about how the love of her life was on a date while she was outside in the cold. Members of the jury, do not fall for these distractions. No matter how much they paid for them, no matter how much they paid an expert to tell you about one pothole on a county road, or how they had a best friend who Jolene has saved from a legal trouble before coming here and speak to it. Do not fall for these distractions. In a few moments, I will sit down and the judge will instruct you, and he will tell you, if you find Jolene Tremont guilty of second-degree murder, convict her. And I ask you to do the same. Thank you.
Thank you.
Can I?
Okay, we're gonna take a short recess and then we'll be right back out. Let's take that back.
Thank you.
That's right. I'm joking. Nice to meet you guys, man. Hey, thank you. I'm not as, yeah, that's the only way I can do it.
I think we're all good. Yeah. I mean, we don't need it anymore.
Where y'all listening from?
This is.
I'm in leadership, and they're gonna be. Where y'all listening from?
How about you?
Birmingham, but.
You tell them that I need.
We'll see. No, I'm not. I can tell. We will.
You have to. I mean, who knows?
Like close the term like still.
But I did say,
Yeah, that's definitely hard. Yeah.
I can do it on your match. It's only 500 words. It's gotta be 500 words. Like that's what he's expecting.
I'll take it.
Which is like early with that.
That was absolutely not bad. I say no, absolutely. The thing that was absolutely Jason just Justin
Are you ready?
I'm sorry. All right, we'll come to order to proceed. We have turned in our ballots, so that's been done. So we can ask you where you're from, much comment about performance. And before we do that, I'm going to ask, first I'm going to ask you to stand up, tell us what school you represent, state your name again. Judge Davis is on Zoom, is that correct, Judge Davis?
I am on Zoom. Can everybody hear me?
Yep, we can hear you.
Yes.
Okay.
Yes.
We're going to shortly let you critique them, and then Katie will and our close. Will that be okay?
That's perfect.
Y'all stand up, tell us.
So my name is Rebecca Smith. I'm with Faulkner University.
My name is Varian Shaw. I am also with Faulkner University, and I'm from Birmingham, Alabama.
All right.
I'm Justin Gillette, and
This is Michael Knopfler.
we're from Harvard.
Harvard, okay. All right, Judge Davis? Did you
So,
have-
I thought everyone did a great job. I know a lot of work goes into preparing for these competitions. I was highly involved in the trial team when I was in law school. Just so you know, by way of background for me, who's judging you, I'm a business litigator in Florida. And I gave my email to Jennifer to disseminate to you guys if you want individual feedback, rather than, I know you're all tired and ready to get on. So rather than me go through and provide critiques, anybody that's interested, feel free to shoot me an email. And if you want to write it down, my email address is bdavis@jimersonfirm, JIMERSONFIRM.com. But overall, well prepared, and I hope you guys have all enjoyed Oxford, Mississippi. I wish I could be there with you.
Thank you, Brian. We appreciate you. My name is Katie Hester. I am the faculty advisor for the trial ad team, and I've been around this weekend, but trying to not be too involved so that I could sit up here with you today. It was quite the show, and I appreciate every one of yours works. I actually went to law school here, but then practiced. I was a civil litigator for a little while, and now mainly teach writing and advanced legal analysis. But I also make sure that everyone knows what the bar exam is before they leave the law school. Interestingly, I actually practiced before Judge Mills, never in the courtroom, but my writing was always before him. I think that it was pretty good, though, right, Judge Mills? Yeah. Anyway, I don't really have a huge number of comments. I would say, though, one of those things that's really interesting is when there's a little bit of a hitch, right? And it felt like the demonstrative turned into a little bit of a hitch. And so you'll probably see on my comments, it was like, this was a good idea. Then it became a little long, right? And there was a little bit too much focus on it in some ways. Justin, I thought you handled it well, right? I did think that all the objections were well taken. I don't know if you noticed, but Judge Mills is pretty quick. And you handled that very well and kind of adjusted to his style as you should, because he's the judge, right? Really nice presence in the courtroom. I know he's going to tell you about the podium. I'm very used to that personally, but you handled that kind of very well as well. You know, there were a couple of small things. Barry, man, your closing argument, I love that story. I'm into this story. You turn your back on me a couple of times.
I apologize. Yeah.
But
I did.
I'd watch turning your back just a little bit.
Yes,
right?
ma'am.
But Rebecca, your tone really nice and very soothing in lots of ways, which I think is always a good thing for a trial attorney. Justin, yours is much more kind of booming, but your presence is really, really nice. You remind me. You gonna tell him? No. I was gonna tell him that you remind me of one of our advocates who has this really nice kind of even tone that I always appreciate a
I
lot.
thought you were gonna say Joe Burrow.
We just talked about that for like 10
So
minutes.
we've been joking in the
Yeah,
chambers
yeah,
that
yeah.
you have other business to attend to. It's kind of, I don't know if you've noticed, judgmental is entertaining. For sure. Michael, your opening was really strong. I felt that it absolutely set the tone for the whole defense, and I appreciate that. There were a couple of strange things, like I kept trying to figure out where some things were going. So you'll see that in my notes a little bit. But otherwise, I mean, much better than I could have ever done. Thank you.
And Katie, thank you for inviting me to this.
Oh, it's always kind of, invite's always open, sir.
Judge Davis, thank you for your patience with us. We've worked hard to keep everything on the screen. I had just a few comments, and I told you I would tell you about the podium. And I didn't understand that you'd be trying to direct all the evidence of me. But the staying within touch of the podium is a general rule, and it's I think it's $100 fine if you violate it in Oxford before Judge Biggers and me. The reason for that is we had a television lawyer show up, and he liked to perform as much as he liked to win. And he would always ship in a bunch of people to see him, and his big he would file these motions for a temporary injunction, hopefully without notice, but with a lot of attention, and bust all these people in to watch him. And he would move around the courtroom, and his persona would change from question to question. He might start off at the podium. Well, would you give us your name, sir? Yes, my name is Katie Hister. He would run over here, and I ask you, madam, and this Shakespeare would come out, and he would be looking over here, and then he would run out here in the audience. So the only way to deal with that in advance is require the attorney, at least when he's speaking to the court, to be within an arm's reach of the podium. And sometimes he would start, and he'll go like he start punching toward. He won't say anything until he gets back to the podium. That's just something. That's a local thing, but it seems to be the only way we can deal with that problem. And Rebecca, you had to be the first one.
I did. And I realized, about 5 minutes in, I was like, I bet this does not mean I need to keep my name.
That's right. But it keeps you in focus, and for here, it kept you on camera most of the time. And I know you all wanted to run around the courtroom, but I wanted to keep you here. That's the reason for that. Use of reaction to a trial, you always have to be prepared for the unexpected. You need to have a story in mind and an ending that you want to get to, but you got to let that narrative change as you go along, and don't show a frustration. The point over the demonstrative evidence, and in my defense, I read the rules last Friday and came in here cold today, which is probably the fairest way to do it. But I remembered something about not objecting to exhibits or something that had been agreed upon. I didn't think it necessarily applied to demonstrative evidence, which is developed in the courtroom. Justin got hit by that, but recovered well. And I thought you handled that extremely well. In fact, well, you actually demonstrated your case on the evidence, and that's how you react. That's called situational awareness. You always know where you are and how what you do affects everyone in the courtroom, the jury, the judge, the bailiff, opposing counsel, everyone. Rebecca, you didn't handle it so well once, and there was some of the retort that I did not understand but overlooked. I don't think it got on the record.
I apologize.
Huh?
I said I apologize.
You stand up when you speak.
I apologize.
What did you say? I didn't understand you.
I don't know.
Oh, well, I thought it was directed at me.
No, I don't think so.
Okay.
I did not say anything mean about a judge.
Okay, and that's the other thing, you segue into, the vanity of judges. There's no end to it. And if you can't be humble in the courtroom, fake it till you find it, you will get a long way. Isn't that right, Katie?
I agree, yes, sir.
And so that would be what I would say. Learn to improvise, use your wit, use it well. And you all did a great job. I would hate to have to go up against any of it. Did very good. That's all I have.
Thank you very much. That's the end of our comments, and I'm waiting for Jen over there who might have.
Yes, so thank you all very much. We have a reception set up downstairs. It's Taylor Grocery, which probably doesn't mean much to y'all who don't go here, but for us, right? So it's already all set up. You can go ahead and head down. And in about an hour or so, in Weems, which is where we did opening ceremonies, we'll do closing ceremonies and give out awards. So see you down there.
Oh, yeah.
Oh, yes.
With the judges. Oh, gosh.
Look at what?
They want to take pictures.
We're gonna turn around Judge Stevens.
I'm going to step out and let the man in the road back to the
Y'all gonna be able to use it.
Okay. Oh, wait. I'm calling up.